The Charitable and Religious Trusts Act, 1920 is an Indian law created to improve the supervision and management of public charitable and religious trusts. Its main purpose is to let people who are interested in these trusts get information about how they work and how their money is handled. It also helps trustees get legal advice from the court when they face difficulties managing the trust. Under this act, anyone with an interest in a public charitable or religious trust can file a petition in court. They can ask the court to make the trustee provide details about the trust, such as its purpose, value, property, income, and how it is being managed. The court can also order the examination and auditing of the trust's accounts, usually going back no more than 3 years before the petition was filed. Another important part of this law is that it allows trustees to ask the court for its opinion, advice, or directions on any issue related to managing the trust. This helps trustees act confidently when facing complicated situations. The Act also explains how to file these petitions, what they must include, how they should be verified, and how the court will handle them. It also covers how the legal costs should be managed during these cases. The law applies to the whole of India, except where the government says otherwise. It applies to both written and implied trusts created for public charitable or religious reasons. The term court usually refers to the main civil court in a district or another court chosen by the state government. However, this act does not allow the court to decide ownership issues against the trust in these short hearings. The Code of Civil Procedure, 1908, is used for cases under this act unless it conflicts with the act. Overall, the act helps ensure that public trusts are transparent, well-managed, and used for their intended public purpose.
Welcome to the Deep Dive. Today we're getting into the Charitable and Religious Trusts Act from 1920 in India.
That's right. An important one.
Definitely. So your mission today is simple. Get the essentials of this act, understand why it came about, and, its significance. We've gone through the act itself for this, and here's the hook. This thing was a response to, decades of worry about how these trusts were being run, what was really going on there.
Well, yeah, even before 1920, there was this growing feeling, especially around religious bodies, that maybe funds weren't being handled right, a lack of openness, really.
Okay.
The main law back then, the Religious Endowments Act of 1863, it just wasn't perceived as effective enough. People wanted better tools to make sure these trusts operated properly. It was a slow buildup of concern, finally leading to action.
Got it. So this 1920 Act, what was the big plan? Its main goal?
The Act itself actually says it pretty clearly. It's for more effectual control over the administration of charitable and religious trusts, basically. More transparency, more accountability.
Simple goal, big impact, I imagine.
Exactly. It aimed to change how things were done.
So how did it try to achieve that? I saw something about Section 3, empowering any person having an interest. That sounds potentially powerful.
Oh, absolutely crucial. Section 3 is key. It lets someone with a real stake. Now, the Act doesn't define interests super clearly, but courts generally say it means more than just being nosy.
Right, a genuine connection.
Yes. That person could go to court and ask for specifics. What's the trust's purpose? What property does it hold? How's it managed? What's its income?
Wow, okay.
And importantly, they could ask to see audited accounts for the last 3 years. That was a big deal for letting the public sort of peek behind the curtain.
A watchdog function, almost. So empowering the public. Check. Did it do anything for the trustees themselves? Offer any support?
It did, yeah. That's Section 7. It allows trustees to actually go to the court and ask for opinions or directions on managing the trust. Any tricky administrative questions.
So guidance.
Exactly. And this is important. If they act based on that court advice, they're legally protected. It's like a safety net for them when making difficult decisions.
Makes sense. So it wasn't just sticks, there were some carrots, or at least guidance. Okay, but what if trustees didn't cooperate, refuse that Section 3 information requests?
Well, Section 6 comes into play there. If a trustee fails to provide the info without a really good excuse, the Act considers it a breach of trust.
Okay, serious stuff.
It is. And that breach could then open the door for a lawsuit under Section 92 of the Civil Procedure Code. That's the section dealing with public trust issues and mismanagement.
Right.
And here's the kicker. Usually for a Section 92 suit, you need the Advocate General's okay first to stop frivolous cases. But for a failure under this act, you didn't need that permission.
Oh, so it streamlined the process for accountability.
Precisely. Made it easier to hold non-compliant trustees responsible.
Interesting. Were there trusts this act didn't apply to? Any exceptions?
Yes, Section 9 lays out some exclusions. You couldn't use this act if a Section 92 CPC suit was already happening for that trust.
Okay, avoids doubling up.
Right. Or if the trust's property was already under the control of certain official bodies, like the Treasurer of Charitable Endowments. Or if there was already a management scheme approved by a court.
So respecting existing legal processes or structures.
Exactly. Prevents things getting messy or contradictory.
What about appeals? If a court made an order under this 1920 Act, could you fight it?
Nope. Section 12 is very clear. No appeals allowed on orders made under this act.
Really? Why so final?
It really underscores that this act was meant for quick summary proceedings. Get the information, get the guidance, resolve that specific issue, but don't let it turn into endless litigation. Keep it focused.
Okay, let's pull back a bit. You mentioned the 1863 Act earlier. How did this 1920 law try to improve on that situation? What are the specific failings it addressed?
Well, the 1863 Act was seen as cumbersome. It didn't give ordinary people a straightforward way to raise concerns about mismanagement. The 1920 Act was a direct attempt to fix that.
So easier access for the public.
Yes, and less expensive too. Before 1920, there were actually other attempts, private member bills and legislatures, even a Bud conference in 1914 with different religious communities discussing the problems. All that fed into the 1920 Act.
A long time coming then. How have the courts looked at this act over the years? I think you mentioned the burden of proof for showing a trust is public.
Absolutely. That's a key point from case law. The courts have consistently said, look, if you claim a trust is public and therefore subject to this kind of oversight, you have to prove it.
It's not assumed.
Not at all.
Yeah.
Just because the public uses a temple or something doesn't automatically make it a public trust under law. You need to look at the founding documents, the intention. Cases like Mahant Ramsaran Das really highlight this. It protects genuinely private arrangements.
And the court's role under Section 7, the guidance part, is it meant to solve massive disputes?
Not really. The interpretation, like in Evak Divar, is that Section 7 is for advice on clear administrative matters. It's not designed for the court to wade into really complex, contested legal fights that would need, a full-blown trial. It's advisory. Summary.
Okay, so wrapping this up. The 1920 Charitable and Religious Trusts Act was fundamentally about boosting transparency, right?
Yes, transparency and providing mechanisms.
Mechanisms for the public to ask questions, get information, and for trustees to get clear guidance. For public trusts, specifically?
Exactly that. Oversight on one hand, support on the other.
So for you listening, knowing about this act helps understand how these vital organizations, charities, religious endowments are supposed to be overseen. It shows the tools available for accountability. And maybe a final thought to leave you with. Considering where this act came from, those decades of concern, and the tools it created, what does it tell us about that constant balancing act between, the public's right to accountability and the autonomy these organizations need?
That's the ongoing question, isn't it? Finding that right balance.
It really is something to think about. Thanks for joining us for this deep dive.